I'm Nancy Cavey, National ERISA and Individual Disability Attorney. Welcome to Winning Isn't Easy. Before we get started today, I've got to give you a legal disclaimer. This podcast is not legal advice. The Florida Bar Association says that I've got to say it, so I've said it. Nothing is ever going to prevent me from giving you an easy to understand overview of the disability insurance world, the games that disability carriers play, and what you need to know to get the disability benefits you deserve. So off we go. How much are you entitled to when you file a claim for your long-term disability benefits? If you're totally disabled, your benefits are going to be based on a fixed amount that you purchased and perhaps maybe even bought some additional increases. You may have started with $5,000 per month in coverage, but you've exercised options that let you buy it up and now have $6,000 worth of coverage. That's pretty easy. But what if you've got a residual disability benefit claim? Now, residual benefits are based on your covered before monthly income. Your policy may say, look, to determine what your before monthly income is going to be, we're going to look at your income tax returns. And we're going to base this on the highest 3 out of 5 year earnings, or the highest 1 out of 2 year earnings, or the 12 months before you became disabled. Some policies will say that bonuses, commissions, or other designated income isn't included in the BME. And that can be a problem because what you thought you bought in terms of coverage may be something completely different. So if you're self-employed, like a doctor, a dentist, or a lawyer, some of these policies are going to say, look, calculate your benefits. We want to see your monthly P&Ls, your billing documentation, or other income before we can determine not only your before monthly income, but your monthly income. Now, why is all of this important? Well, because the calculation of your before monthly income is the starting point to calculating your benefits. And that calculation is going to be done monthly. So today's episode is all about the wonderful world of before monthly earnings calculations. And the three things that I'm going to be talking about are how pre-disability earning language can impact the amount of your disability benefits, what the court says. In other words, the court says just because a carrier or an employer thinks their calculations of pre-disability income earnings is correct doesn't make it so, and why discretion can make all the difference in your disability insurance claim benefit calculations. So let's take a break for a moment before we get into today's episode.
Have you been robbed of your peace of mind from your disability insurance carrier? You owe it to yourself to get a copy of Robbed of Your Peace of Mind, which provides you with everything you need to know about the long-term disability claim process. Request your free copy of the book at caveylaw.com today.
Welcome back to Winning Isn't Easy. Let's talk about one court that said just because the carrier or the employer thinks that their calculation of pre-disability earnings is correct doesn't make it so. Now, I want to tell you the story of an obstetrician by the name of David Schweitz. Unfortunately, Dr. Schweitz became disabled because of a vision loss, a retinal tear in both of the eyes, and a right macular hole in his right eye. He applied for and was granted his short and long-term disability benefits. But guess what? Aetna Life didn't want to pay disability benefits based on his employment agreement. And that's the other starting point in this analysis. In other words, we want to look at any employment agreement. We're going to want to look at income tax returns and other financial documents. And of course, we're going to look at the policy definition of pre-disability earnings or before monthly income. Now, in this particular plan, pre-disability earnings was defined as the amount of the salary or wages you were receiving from an employer participating on the plan on the day before a period of disability started, calculated on a monthly basis. So let's work through the facts of his case and see how this actually worked out. He became disabled on February 4, 2015, and his pre-disability earnings should have been calculated based on his salary as of February 3. Dr. Schweitz had entered into an employment agreement that provided that for the first 2 years of employment, he had a base salary of $322,689, and that years 3 to 5 were to be calculated in part on this base agreement so long as he met certain productivity standards. If he didn't meet the productivity standards, his base salary for the deficit quarter was to be recalculated. So you can see a lot of math here. Now, this agreement did not allow his employer to reduce his salary on the first day of the third year, but of course they did. And there was a subsequent written agreement that confirmed that his salary would be maintained at the $322,689 number through February 28, 2015, and wouldn't be reduced to $156,011, which is what the employer was paying him. So, of course, guess what Aetna wanted to do? Aetna wanted to pay his benefits based on the $156,000 salary and not based on the $322,689 salary. You can see that's a heck of a difference in benefits. So, of course, this ended up in federal court. And for federal courts, really what happens is they have the ability to interpret the terms of the policy. And that normally is their starting point. And if there is an employment agreement, they're also going to be looking at that employment agreement. They're not necessarily going to agree with the carrier's calculations or the employer's position regarding what the before monthly income is. And in this case of Schweitz versus Aetna Life, Judge Blakely noted that Aetna had failed to justify why they used the lower number. Of course, we know why they used the lower number. They didn't want to pay full benefits. They argued that the lower number was right because the employer said it was right. And the judge basically said, look, what you think is right, what the employer thinks is right, is irrelevant because it's my job as the judge to conduct this analysis by looking at the terms of the policy and the employment agreement. And basically what happened was the judge said, too bad, so sad for you guys. I'm going to do my job, and found that Schweitz's salary was governed by the terms of his employment agreement and ordered Aetna to calculate the earnings based on the $322,689. Obviously, that was a great result, but you can see that there are cases where the disability carrier will miscalculate the BME in the favor of the policyholder, and they will miscalculate the benefits in their favor. Some of this is intentional, some of it isn't. But in any event, you do need to understand that this is one of a very contentious area in the world of disability insurance. Carriers generally don't want to pay full benefits, and of course you want your benefits to be paid at the correct rate, the rate that you basically contracted for. So that obviously in this case, it was a great result. And that was a great result because we had a judge who was willing to do their job and willing to look at the facts of the case, the employment agreement, and the contract, and render their own independent judgment. Let's take a break.